Shall I start? Good morning, sir. I welcome you.
Good morning.
I welcome you all in the day 2 of the webinar series organized under JLU Ramjethmalani Chair for Criminal Law and Criminal Justice, JLU School of Law, Jagran Lake City University. Topic for today's webinar is criminal procedure, emerging issues and challenges. Criminal law is one of the most crucial branches of law as it directly impacts day-to-day human behavior. The existing criminal justice is plagued by many problems, including inordinate procedural delay and low conviction rate. There is an imminent need to reconcile the law with the realities of the contemporary society and to make the criminal procedure more accessible, speedy, and less complicated. There is also criticism regarding arbitrary arrest and the alleged hide-handled behavior of police officials. It is indeed an uphill task to strike the delicate balance between the powers granted to the officials involved in the administration of criminal justice on one hand and the protection of liberties of the suspected offenders on the other. In light of such issues and challenges faced by Indian criminal law, there is an urgent need to deliberate upon the various aspects of criminal law that are in need of reform and amendment. It's my proud privilege to introduce you to our guest for today's webinar, respected Professor Dr. Bajpai, Professor and Registrar, National Law University, Delhi. Professor Bajpai serves as Professor of Criminology and Criminal Justice, Chair Professor at JLU Chair in Criminal Law at National Law University, Delhi, and also as the Chairperson at the Center for Criminology and Victimology. He is also the Registrar, National Law University, Delhi. Professor Bajpai has authored 15 books and more than 80 papers, 10 project reports, and several monographs. His books, Witness and Criminal Justice Systems, on cyber crimes and cyber law, situational crime prevention and crime reduction, and victimological narratives on gender violence have been well received. He is the editor of 3 prestigious international journals, Journal of Victimology and Victim Justice, published from the SAGE, Journal of National Law University, Delhi, published from SAGE, and a publication, an Indian Journal of Criminology, a publication of Indian Society of Criminology since 1972. Professor Bajpai also contributed significantly in police training research. He successfully implemented a series of vertical interaction courses for IPS officers and also coordinated training projects with Sheffield Hallam University. Recently, he was conferred upon the ISC Kumarappa Reckless Award, the highest honor and award of ISC in recognition of significant contribution to research, teaching, and administration in the field of criminal justice administration. He is also the president of Indian Society of Victimology. Recently, he has been elected to the Executive Committee of the World Society of Victimology. Professor Bajpai, appointed as an expert of Manav Rachna University in April 2019. He is also appointed as a member of the Standing Committee on Research Methodology for research projects of DPR&D. Sir, over to you.
Thank you, Dr. Shobha. I welcome all the students and participants who are attending this lecture on criminal procedure reform. Since we are doing it on a digital mode, if any time my audibility becomes an issue, the organizers may just, remind me.
Yes.
Am I audible? Am I audible correctly?
Yes, sir. Yes, sir. Perfectly, sir.
Okay. So, friends, the task before me is really very, very vast in terms of various issues that can be covered, but in a duration of some 45 minutes to 1 hour. We will try to look at the key issues in the criminal procedure code and its impact on criminal justice system from the viewpoint of appreciation of reform that can be undertaken. My first proposal is that let us revisit the criminal procedure law from the viewpoint of Constitution of India. Why I'm saying so, the teachers and the scholars and the students of criminal law often forget that the constitutional foundation of criminal law is very, very important. And this is one area which is now becoming very, very crucial and important for one very important reason. That is, the touchstone of the validity of criminal law is the constitutional parameters. So in my lecture today, I'll begin with those constitutional requirements which are the solid bedrock of the criminal procedure, and we will see how that connection becomes important. The concern in the reform proposal at this stage is that let us identify the disjunct between the criminal law and the constitutional law. When I look at the Constitution, I find generally we think that it is the Article 21, 14, 15, 17. These are 15. These articles are very important. Definitely, they are important because the Supreme Court judgments and the High Court rulings, they are invoking these sections very often. But I'll take you to the Chapter 3 of the Fundamental Rights, which is very important. And in particularly, I'm highlighting the basic balancing principle, which is laid down in two clauses of Constitution. So Article 13.1 and 13.2. Every criminal law student must study these two important articles. Criminal law student, constitutional law student would study the entire Constitution. That is all right. Why I'm saying that you should look at these, because they continue to be very, very important. 13.1 lays down that all the existing and enforced laws shall be subjected to a test of inconsistency with the fundamental rights, and any inconsistency shall render the law void to the extent of the inconsistency. So 13.1 requirement of the law being consistent with the fundamental rights. This has not been done in a vacuum. There was a very, very important thinking behind this particular reason and particular article. And not only this, 13.2 prohibits the state from making any law that tends to abrogate or abridge any fundamental right by virtue of 13.2. Now it shall be rendered void. So these two articles of the Constitution for me are most important from the viewpoint of the consistency with the fundamental rights. So my first proposition is that we need to look at the criminal laws on the touchstone of constitutional consistency, especially with regard to Part 3 of the Constitution, that is the fundamental rights. Now, constitutional foundations are basically very, very human and liberal basis of criminal law, because need for humanizing the criminal law is very, very important. I think you all know criminal law is a very crucial law because that is the only law which has a potential to invade and to interfere with the personal liberty and life of the people. There is no other law which has such kind of potential. And when this law is given to the law enforcement authorities, you will find there are every chance that they may abuse the provisions of the law for the purpose of compromising the fundamental rights of the people. Now, a very important check and balance principle is therefore necessary. In a rule of law country, in a constitutional democracy, the checks and balances on criminal law is the first and foremost requirement. Otherwise, if criminal law goes untrammeled and uncontrolled, it becomes a curse to the democracy and it has serious implications. That's why criminal law is always discussed in the context of its abuse. Criminal law is always discussed in the context of the kind of liability it creates on the part of people. But 21st century's understanding of criminal law is in terms of the rights that this law is capable of conferring to the people of this country. Now, the rights to life and liberty provided in the Constitution continues to be very, very important as far as criminal law is concerned. So whenever the limits of criminal law is exceeded, this particular Article 21 comes into play, and you all know Menka Gandhi judgment 1978, SCC 248. This actually judgment has brought the due process and fair and just process. And fair and just procedure established by the law, it should not be indiscriminatory, it should not have any kind of. Now, second is, which is very important, Article 20. We talk Article 20 or especially Article 20 subclass 2. Why I am discussing? Because any proposal of reform in criminal law will go back to these provisions to test and check whether the laws are consistent with these provisions or not. So no person shall be prosecuted and prosecuted for the same offense, double jeopardy protection. And you also look at probably the criminal law student would particularly like to see the Article 22, subclass 1 and 2, which became very important in the recent time from the viewpoint of arrest. Now we know that this is the only law again giving powers to the police for arresting the people. Now, law of arrest is another provision which is often considered to be very, very crucial, because the moment a person is arrested, his right to liberty is compromised. Now, this law says, the Article 22 says, grounds of arrest to be informed. That is very, very important. No arrestee shall be denied the right to be and defended by the lawyer, and production within 24 hours before the magistrate. Have you ever thought these provisions have been entered into the Constitution, not in the criminal procedure first, in the Constitution? So you can very well understand the supremacy of the Constitution, and especially with regard to the rights, fundamental rights. And similarly, the Article 14 also becomes very, very important, which is talking about the equality. Because equal protection of law is something which is again becoming very, very important. We can discuss certain cases also and certain, the recent instances. But for me, again, we know that Constitution also provided a fundamental basis for the just operation of criminal law. Just operation of criminal law is informed by various arrangements which have already been provided in the Constitution, like the Article 39A, legal aid, 42nd Constitutional Amendment. These things are very, very fundamental. Constitutional remedies. So 226 and Article 32. Why we have provided? Because ultimately the entire operation of criminal law revolves around some of these, issues. Now I'll come back to a very important discussion from the viewpoint of criminal law procedure reform. That is the FIR part, especially the section 154 and 155, where pre-investigations, you know, there are two very important judgments with regard to FIR. You can ask me why suddenly I have come to FIR. Because for me, FIR not simply a complaint which is registered with the police for the purpose of or in connection with a crime. No, please remember, FIR is an effort on the part of aggrieved person to seek the access to justice. The first test of criminal law in terms of access to justice lies in the effective and efficient operation of section 154. Because if the person is denied the entry into the criminal law or in the criminal justice system, then the entire purpose of the law is lost. How many of you would know one thing very clearly? Because the popular understanding of criminal law is the fact that criminal law is there to punish the people. Punishing the people cannot be the objective of any law. Yes, punishment is one of the characteristics of the criminal law, but it is not in a vacuum. And I'm telling you, redressal is the first object of criminal. Redressal, please remember this word, because if you remember the term redressal, then your entire perspective to understand criminal law will change. Please read all the sections of CRPC. You will find every section of CRPC is some way or the other is trying to redress the problem experienced by the complainant, who is the victim of crime. So, redressal approach to criminal law is very distinct from the retributive approach to criminal law. And in 21st century, we have redefined the objectives of criminal law. I always come into discussion with people on the question of the objectives of criminal law, and I never deny that the criminal law is retributive as well. But this retribution is very distinct from the ordinary forms of retribution which you see in the society amongst the people. Because with the very establishment of criminal law, we recognize the need and objective of retribution on the part of victim so that they do not undertake laws in their hand, and there should be a formal system of satisfying the instinct of revenge in a most amicable and formal manner and in a just manner. So even the punishment cannot be arbitrary. The rights of accused have been kept at a very high pedestal as far as criminal law is concerned. You will have to understand this thing. Many people at times get little disturbed that why the rapists and murderers are being protected. Sometimes we think that we are very happy if Vikas Dubey is encountered and killed. Why people are happy? People are clapping, that's fine. But as a student of criminal law in the long run, you will realize that the advent of criminal law has happened to overcome such kind of things. We wanted to overcome encountered and personal killings, personal revenge. That's why we have set up a state, formal state, sovereign state, giving certain powers to the law enforcement agency, legislature, and judiciary. So people feel happy when criminals are vanished, criminals are liquidated. But I'm telling you, this is going to be a very, very disastrous thing for civil society, for a constitutional democracy. Because you have to find out the ways to effectively deal with criminal. That would not mean that these are the only way. That's why I'm saying, let me come back to the point that you please read CRPC very carefully. So on the one hand, you will find, I think it depends how do you read CRPC. I think art of reading CRPC And you can discover it's like Gita. If you read Gita on day-to-day basis, you will come to new meaning of Gita. CRPC is a Gita of a criminal law scholar in a sense, because every time you will come across some interlocking provisions. Please read comparative sections, very interesting. So on the one hand, police is vested with the power of arresting the people, but at the same time, accused has been provided with the power of protection, not to be arrested, not to be interrogated, not to break his or her silence, to adduce certain testimonies or evidences which go against him. Self-incrimination. Self-incrimination is protected in the Constitution. So, have you ever thought why the rights of accused have been kept at a very high pedestal? Thing will have to be, understood. And you will realize that there was one fundamental reason why the rights of the accused have been kept at a higher pedestal. Because the accused is one person who is facing a very mighty state. The state is very powerful, and accused has to defend himself or herself against the might of the state. And might of the state is something which is very, very important. Now, we also have certain provisions which we have recently come across, especially as I have just mentioned that the Station FIR and Lalita Kumari 2 judgment, constitutional bench judgment, they have said once a report comes to the police disclosing the occurrence of cognizable crime, the police is duty bound to register the crime. Which means there is no choice before the police but to register the crime. Now it looks very simple that you walk in police station and crime is registered. But there are several instances of such kind where you will find that the police do not register crime often for this reason or that reason. But we find that this is something very important, and police had to file its report under section 173 to close a report. But in the meantime, a lot of things happen which comes under the categorization called investigation. So investigation includes, after receiving the report, after receiving the FIR, when police starts moving to crime scene, making arrests, collecting the statements, taking statements, all these things are very, very important. Now, certain very important things which are important from the viewpoint of reform or viewpoint of human rights protection is something which you will find in the section 57 of CRPC. So, police cannot confine a person beyond 24 hours in the custody. However, under section 167, powers to magistrate to pass orders regarding police custody remand, which can be maximum for 15 days. Let us understand these provisions. And judicial remand for 15 days. But even judicial remand shall not exceed beyond 19 days in case of offences punishable with the imprisonment above 10 years. So that's not more than 16 days. So 16 days and 19 days, two limits we have prescribed. This is something very important because the makers of CRPC were aware that keeping a person in the police custody is not a great idea. It is always for the purpose of investigation and interrogation, not for the purpose of torture or, any extralegal mechanisms. But you'll realize that the custodial torture instances, we have seen in Tirunelveli very recently, a very ghastly act has happened because the magistrate did not apply his judicial mind on the request of providing custody to two ordinary persons who were shopkeepers. And police had to settle some previous scores with these two persons. These two persons were taken to the magistrate, and magistrate routinely allowed the judicial custody of these two persons. Mechanical application on the part of magistrate on the request of judicial or for that matter police remand is something which in this country is happening day-to-day basis, and which is the main reason of police excesses and custodial. But it is not the fault of criminal procedure law. Please remember, criminal procedure law is very clear that before, when after 24 hours the accused is produced before the magistrate, his medical examination is very much important, and next time when he's produced before the court for remand, judicial remand or any other remand, then also he has a right to press for medical examination. But I notice that because of the non-invoking of certain sections, I remember in after the NHRC came into being, and they have brought out these things very significantly, that the police has become a major agency torturing the people. And you will remember that in IPC two very important sections exist, because these days I have seen after Tuticorin instance of judicial this torture and all that, they said that we don't have any law. But if you go to IPC under section 330 and 331, very clearly lays down that any public servant having the custody of any person, if voluntarily, presses someone to extort confession by applying force, actually constitutes an act of grievous hurt to be, punished by 7 to 10 years of punishment and all that. But I am saying this is one very important area where the reform is possible. Second thing, I'll again come back to the laws relating to laws relating to arrest. You will find that long back the police commission said 65% arrests are unnecessary, and you will find section 49 to section 60 of CRPC provide some vital pre-trial rights to the accused. Please read this section. This section do not use the word right, but you will, a clear bare reading of these sections 49 to 60 will give you an idea that what are the pre-trial rights of the accused, especially relating to the person who have been arrested in connection with various crimes. For instance, section 49. Section 49 says no unnecessary restraint would be exercised by the police. No unnecessary. Reasonability of the force to be applied by the police has always been considered to be a valid factor. Now, this reasonability gets violated the moment police oversteps, and therefore, section 50. Section 50 is a protection. You have to inform the ground of arrest, because all illegal arrests are informal arrests executed by the police, do not involve the mentioning of the ground of arrest. Ground of arrest means that ground should be legally valid. Ground of arrest means it's not that I want to arrest you, so I am arresting you. Grounds of arrest to be read legal term. And 50A, obligation of the arrested to inform a nominated person about the fact of the arrest. Somebody has to be informed in the family or anybody whomsoever the arrestee wishes to do. And now the medical examination is a legal requirement under 53. But oftentimes these requirements are flouted. And we notice that the important development, I think the most sensational chapter in the CRPC, I always say, it is the chapter relating to arrest. And reason is, we all know D.K. Basu. For a long time, we have been reading about D.K. Basu and arrest. But D.K. Basu is no longer D.K. Basu because it is now the part of CRPC section 41A to 41D. 41A to 41D, basically these sections specify certain conditions to be followed by the police in case of arrest is made, and every offense punishable with less than 7 years of imprisonment obligates the police to put out detailed information about these arrests in the public domain. So anybody who is being arrested, a record has to be kept. Now, very important, section I'll take you the judgment. I'm sure you must have read the judgment of Arnesh versus the state of Bihar, 2004. If you have not studied this, please do that, because that is one judgment which has really brought into notice a variety of things which will be very important from the viewpoint of. So the first thing that they say, that all the state governments to instruct their police officers not to automatically arrest when a case comes to them. Please remember, this was the case relating to 98A. Arnesh is a judgment which is worth reading. Please read this judgment. There are some judgments which you cannot avoid reading. These are the landmark judgments. I am not asking you to read everything, but certain judgments you must read. Please don't forget to read this if you are not. So this is one test case which is relating to the cruelty relating to dowry, 498A. We know that this is one section because of which a lot of people are easily arrested. Even the Supreme Court says that there is a certain degree of misuse of this section. And therefore, in this case, also an arrest was made, and the arrest was found to be unnecessary. And 8 directions relating to arrest were made by the Supreme Court in this judgment. So these 8 judgments, 8 guidelines, directions. So first judgment, first direction that the court made, that please do not automatically arrest. First, they have to see whether the law is satisfying the requirement of the requirement laid down in the section 41 or not. Second requirement was a checklist. Police officer is to be provided with a checklist containing specified subclasses from 41 1 to B2, subclass 2. And then the police officer shall forward the checklist duty to furnish the reason and material which necessitated the arrest. And the role of magistrate was particularly emphasized in this judgment. And you'll see that the magistrate was asked to ensure that the arrest is fully lawful, and failure to comply with the direction would make the police officer liable for certain action, departmental action. Now, these guidelines regarding the protection of accused from the arbitrary arrest is something which is very, very key. Because let us understand in between that the purpose of criminal law was never to provide untrammeled powers to the law enforcement agency so that they can misuse. And the Ashwath says that the criminal law should be the last resort in a civil society. Why? Have you ever thought why criminal law should be the last resort? Because the moment criminal law is brought into action, it has severe implications to the rights provided in the Part 3 of the Constitution, that is the fundamental rights. And fundamental rights are very sacrosanct as far as the Constitution of India is concerned. So criminal law should not become a tool to sort of compromise the precious rights which have been provided to the people through various reasons. But one thing that I would like to tell you that in all these sections, we have to cover one very important thing. The CRPC has provided certain important protections, or you can say the arrangements to the accused. One such arrangement is in the section 235(2) and 248(2). Please again read this section. There are many things that I'm not touching everything, but I'm picking up something very important which is not ordinarily taught in a general class of CRPC. That's why you will find the criminal law students in this country are not much aware about the sentencing process. Sentencing is very, very important to the in the interest of clarity. I would add that this stage comes when a person has been found guilty of an offense and the court has reached the conclusion that yes, this person is guilty based on the trial and the evidences which are brought before the court, and court has come to this understanding. Now, the Indian Penal Code is very interesting in the sense that it doesn't provide fixed punishment to any kind of, except few offences where mandatory minimum is provided. Otherwise, the scale of punishment is provided. So scale of punishment means there is a range, like minimum 3 years, maximum 10 years or 7 years. Now, sentencing is one stage at which the determination of the quantum of punishment would take place. Now, pre-sentence hearing is another right of the accused that you need to detect. This term doesn't figure in the CRPC, but I am reading in the CRPC. To me, the pre-sentence hearing rights of the accused are very important. So two sections you need to specifically look at: 235(2) and 248(2), where judge has been obligated to accord a hearing to the accused before passing a judgment. Similarly, 360 and 361 obligated the judiciary to reformatory sentencing measures such as release on probation and disposition under the juvenile justice laws. These four sections you have to read together to understand the progressive outlook of the judiciary and progressive outlook of the CRPC. In the beginning, I said I always read CRPC as a law not creating liability or providing sanctions. I read CRPC as a right conferring module. It provides certain rights to the people who are the stakeholder in it. So the most crucial stakes are with the accused. And the accused has been provided with a lot of pre-trial protections, pre-trial rights. So these two rights. Now, what happens to these two rights? These two rights have been very, very important. Especially, you must have heard these two rights in the context of death penalty. Death penalty continues to be a very, very debatable topic. But since death penalty is the most crucial punishment, because it relates to the life or death of a person, and so there is always an effort on the part of the lawyers that the death penalty could be converted into lesser sentence, life sentence. So what should be the criteria? Criteria is invariably decided at the stage of sentencing. So sentencing, though it is important in all the cases, but more so in case of death penalty, because a life is being saved. So the court has to balance the factors, two types of factors, aggravating factors and mitigating factors. Now, court has to reach to this conclusion that how these two types of factors are, balancing. And if court finds that the mitigation factors are many, age, background, first offense, so many ways, prospects of reform, then the court might decide otherwise. I mean, the death penalty may be set aside and life imprisonment can be awarded. You can see in Catanov cases, this has happened. So you need to very minutely understand the entire philosophy behind the whole process of sentence. The important and the last important thing too, have you ever thought India is a country where a lot of indignant people, poor people are living? Criminal laws, how the criminal laws are addressing the indigent people, poor people who are facing criminal justice system. So I have mentioned that apart from the legal aid, another section which is very important is 436. So court has to release an indigent person who is unable to furnish his surety. If a person, because every offense there is a surety which is attached, and determination of surety is very interesting as far as 436 is concerned. So court says the amendment was made. I'm talking how the law is concerned with the sensitivity of the law towards poor people. So when a person is unable to give bail within a week of his arrest, it shall be sufficient ground to assume that this person is not capable of arranging his surety. This is provided. And these are very important areas which have a lot of things to do with constitution. Just three more points I'll touch, which are very important from the viewpoint of reform. One such area I always find is the fair investigation is one thing. Though I'm going back to what I should have said this little early. Fair investigation, like fair trial, is something which is very, very important, because fair trial we have in Nirmala Singh, we have Nirmala Singh versus the state of Punjab. We conceived that Article 21 contemplates the right of an accused to have a fair trial. Article 21 is a guarantee. This Nirmala Singh case has very clearly brought that this is. Similarly, fair investigation is also very important. And this is happening now because there are lots of arrangements which are being made where we find that the fair investigation is ensured. Now, I'm coming to the very important facet of reform, which is becoming now important in view of the fresh developments. I call it, this is a victim justice reform, the victim related reforms in the criminal procedure. You would easily know that the term victim came to the CRPC only in the year 2008. In 2008, for the first time, the term victim was included in the CRPC. What does it mean? It means that the, the victim was no longer there in the scheme of criminal jurisprudence in India. So we could identify victim only in the year 2008 under 2WA of CRPC. 2WA of CRPC is mere definition. You will not find the term victim. It's a good research for you to look at how many times the term victim came in the entire CRPC. So you will find only the amendments which came after 2008, means only in 2013 the next amendment was made by the Justice Verma committee in the 2013. He has used the term victim at a couple of places. And 257 in the compensation clause also the term victim came. Why I'm saying so, we could not formulate the exact place for the victims of crime in the scheme of CRPC. Minutes ago, I said the accused rights are very clearly mentioned in the CRPC. He has a right to be informed of the ground of arrest, force use, bail, probation, sentence, all these things. But victim does not have any explicit right guaranteed under the criminal procedure code. Therefore, there is a huge scope of reform as far as victim is concerned, and I'm saying there is a need to balance the rights of the victims against the rights of the accused. Balancing of the rights of the two types of stakeholders in the criminal trial is something which is very important. And this is possible in view of number of judgments that the Supreme Court has given in the recent past. So we find a new victim jurisprudence is now emerging. To give you a very quick view of it, I would say that the victim has a rightful position right from the beginning of the FIR registration stage. But at vital places, you will find the victim has no sort of presence. Like, for instance, the prosecutor does not have any direct obligation towards the victim, though the prosecution is one who represents the case of the victim in the court. But you will not find neither the police nor the prosecution being obligated by the force of law in any manner so far as the victim is concerned. Now, this causes certain degree of disadvantage on the part of a person who is trying to access the criminal justice system. Now, the most crucial is, even when the charge sheet is being prepared, or for that matter, the discharge proceedings taking place in the court, which would have the effect of discharge of the accused, the victim is not present in person. I am of the view there are certain stages of the trial where the victim should have a personal presence. like bail hearing, like sentencing hearing. When, on the question of sentence, why can't the victim be heard? You are hearing the accused, you can also hear the victim. I find that there is a huge scope of considering the victim at the different stages of trial. Four things are important: access to justice to the victim, rights to crime victims, fair deal to crime victims by the criminal justice agencies, and protection of crime victims, and then assistance to crime victims. All four, five ingredients of victim justice, it forms the victim justice, are very important. If they are considered, then the law will be very, very balanced, which is not at the moment is. So I am of the view that the CRPC, which is a very important document, I always call the best definition of CRPC is balance. Because CRPC in its original shape tries to balance between the rights of the individual and the rights of the state. The state has certain priorities like security, and individual has, there is a tension between individual freedom and the state security. The state security will often come into clash with individual freedoms. Individual freedoms are restricted by the law, but what should be the limits of restriction on the individual freedom is a very important question. It's a constitutional question, and I am raising this question in an era where even the issue like privacy has become a fundamental right. So if privacy has become a fundamental right, how this is going to impact the operation of criminal law is something that we need to sort of revisit. I'm thinking that the 21st century students of criminal law must look at criminal law in a fresh light. And I'm telling you, if that is done, you will find criminal law becoming a very, very important vehicle of providing a just society, a just order, and the restorative aspects of criminal law, the redressing aspects of criminal law, human aspect of criminal law, liberal aspects of criminal law would be more and more prominent rather than the retributive, harsh, and punitive criminal law and counter criminal law. Because people think that the criminal law would be effective if more and more people are arrested. They think criminal law is effective when more and more people are sent to the jail. They think criminal law is effective and more people are encountered. UP Chief Minister said we have said in the assembly that they have caused 1,200 encounters. 1,200 encounters. All the encounters are extradited. So we have to see what kind of criminal law a society like us would need in the 21st century. So here I finish, and I think I have raised several issues for your consumption, and I'll pick them up for your further research, study, and interest. Thank you.
Thank you so much, sir, for your enlightening words on this vibrant topic. And there are some questions from the faculty members, and the first question is about the sentencing, sir, the sentencing that you were talking about. And as you told that it's very essential that the accused should be heard on the question of sentence. The question that I'm putting is, the judge has wide discretion in awarding the sentence within the statutory limits. Therefore, each judge exercises discretion, which has resulted in lack of uniformity in sentencing. Do you think that there is need for some guidelines to regulate the sentencing discretion of judges in India?
See, this question has been raising all the times because India is one country which does not have a clearly laid down sentencing guideline. So sentencing is left to the discretion of the judge. Though judge is duty bound to hear the accused on the question of sentencing as 235(2) prescribed. But I would say, what does it mean by hearing? जज ने उसको बुलाया और सुन लिया कि हाँ बताओ क्या कहना आपको, हियरिंग हो गई. Hearing means it's not a sort of informal hearing. Hearing means the judge is applying the mind to the facts which are being brought before the judge. So I agree to this point, like in the US or in the UK, they have the sentencing guidelines, and India, I think several times the attempts have been made, but are being made to develop some guidelines. And I fully agree that this discretion must be a guided one to a great extent.
Thank you, sir. Another question is, what reforms are required to promote speedy disposal of cases like domestic violence, cruelty, honor killing, etc.?
I deliberately did not touch a speedy thing for one reason, because we think that speedy disposal means putting a time frame or timeline for certain investigations or certain trials to be completed within a time-bound manner. I think you would agree to me that prescribing a timeline without changing the rest of the system is a tall order. The best example you can see in case of Justice Verma report, where a limit of 3 months was prescribed for trial of a rape trial. But it is not happening. And it is not happening because we do not have specialized courts. In so many cases, like you mentioned domestic violence, you mentioned POCSO, we generally designate the judges to try these offenses. So designating a judge means creating a court. That is not the idea. Creating separate courts under the Act would mean there should be infrastructure to deal with these cases. And I'm telling you this is happening for one reason, because laws are being passed but infrastructure is not being built up. So whenever a new law or amendment is passed, it should also be there that this should be the manpower, this should be the requirement of infrastructure. Otherwise, merely saying that law has been passed, the things will be changing is not something going to happen. So Speedy Disposal Law Commission has dealt very length, and they have also come to this conclusion: a comprehensive reform in all sectors of criminal justice, including police prosecution, should be there. Then only you should expect the speedy disposal in certain cases.
Thank you so much, sir. Sir, another question is, does the criminal justice system require more changes to fight against organized crimes?
We have certain arrangements as far as organized crime is concerned. So like we have passed MOCOCA kind of laws where organized crimes and money laundering and all these offenses. But what happens again that we brought the special legislations dealing with organized crime, but again the similar level of institutions, the manpower, the funding to the agency is not there. I think we need a much specialized division of police to deal with it, because in organized crime there is a jurisdiction of multiple agencies depending on the nature of crime. If it is a drug offense, then NDPS. If it is a financial, it will be, then you'll find the EWA, you'll find VWF, you'll find revenue agencies. But yes, this sector is definitely needs a lot of attention.
Okay. Thank you, sir. Sir, one question is about the encounters. How can the menace of fake encounters be handled?
See, encounter is again the result of a failing system. Criminal justice system, especially the police, they find, and in fact the system is crumbling in certain respects. Like for instance, we always find that the powerful people manage to get away with the crime, because for them the crime is a resource. They are using crime as a means to achieve a lot of things. Encounter is a frustrated response to a failing system. Is a frustrated response to a failing system. I'm telling you, you go to worldwide, not to America. America is also facing the same. You go to other countries, like if you see in many countries in Europe, there is a zero encounter kind of thing. Reason is the system is very efficient. So if you make the system efficient, to my mind, the encounter kind of situation would automatically be vanished. I am not in favor of directly dealing encounter in a very isolated manner. I am in favor of bringing comprehensive reforms in those sectors of criminal justice which are responsible for major failures, which are injecting some sense of disappointment on the part of police, and they think that these criminals will get away with crime and would not be subjected to a law. I think when the system becomes efficient, the chances of people getting away with the crime would be much less. And therefore, there would not be any need of reform.
Thank you so much, sir. Sir, another question is related to prosecution. Always a very, I think, a debatable issue before us. The question is, the burden is on the prosecution to prove guilt of the accused beyond reasonable doubt. It is all the more necessary for the prosecution to be represented by a very able and competent lawyer. If it does not happen, justice cannot be done. What is your take on this, sir?
See, I could not take up because there are many issues, but prosecution reform is again on the agenda. We are looking into a part of committee on this subject. And in the past, some attention is now being devoted. I fully agree with the person who has raised this question. Prosecution has been a neglected segment, and this is very vital because failure of prosecution is largely responsible for the failure of entire criminal justice. And I also agree that not many talented people in law school would come to join the cadre of prosecution. So when I say comprehensive prosecution reforms are needed, the first and foremost thing which I have mentioned a couple of times is that you need to make the prosecution very lucrative as a department or service, like judiciary. You can make it like judiciary. I'm telling you, in the UK, in the Europe, certain countries in the UK, there is a common examination for prosecutors and judges. People try very hard to get into prosecution, not to the judgeship, because police functions under the prosecution in several countries of the Europe. So prosecution enjoys a very, remarkable status. Even in the US, a very known attorney, Preet Bharara. Preet Bharara has done a lot of work, you see. I'm telling you, so prosecution, we have, I don't know, deliberately kept prosecution as a very weak institution. And this is the time to empower prosecution. I am of the very, very considered opinion that there is a huge scope of reforming prosecution. And by reforming prosecution, probably your conviction rate will improve, your efficiency will improve, even the victim justice will improve. Thank you.
Certainly, sir. Sir, another question is related to the that the accused is presumed to be innocent, and he enjoys the right to silence. So, and because of that, a large number of criminals are escaping convictions. So, what can be done in this regard?
See, this is also a very, we have been, as a student, we have been debated on this particular question. The right to silence is something which is also guaranteed in the Constitution, Article 20 plus 2 I mentioned, that one cannot be compelled to be witness against himself or to produce something which is self-incriminatory. Now, right to silence is something which is in the bestest sense of the welfare of the person himself. Criminal law is operated in a manner where if you suppose you snatch this right from the person, then you would not require anything. The person has to sort of say that, yes, I have committed and there is no need for trial. Confession is enough, isn't it? So I suppose the one who accuses will continue to have the burden of proof. So burden of proving the guilt continues to be the responsibility of the prosecution. However, like Justice Malimat's committee wanted this to happen, probably similar reasons. They wanted some element of inquisitorial system to be brought in the purview of our common law system, whereby the judge can play a little more active role in the proceedings, and also at the stage of there is a investigating magistrate who is attached with the police. So a lot of things can be done without really removing this particular right on the part of accused.
Yes, sir. Thank you, sir. Sir, last question. India has always faced the brunt of politically motivated crimes. What are the procedural changes and possible solutions?
So it depends the nature of crimes that you have in mind. I don't know what is political crime because law doesn't define anything like political crime. But yes, if you are saying that any corruption, or if you are saying money laundering, or if you are saying the abuse of power. See, one thing that we are considering in our current reform exercise to define legally what is the abuse of power. Abuse of power is becoming something very, very, serious for various reasons, because people have been, given certain powers when they misuse, whether it's political or administrative power or bureaucratic power. So any form of misuse should be subjected to a legal process. And I think if the liability is created and the accountability mechanisms are improved within the system, like in case of police we have done, or in case of other public functionaries. So accountability mechanisms will have to be improved to really curtail the instances of political protected crimes.
Thank you, sir. Thank you so much, sir. I express my deepest gratitude to you, sir, on behalf of JLU Ramjethmalani, Chair for Criminal Law and Criminal Justice, for sparing your precious time from your demanding schedule. And you enlightened us with your profound knowledge, experience, and acumen on the law and society. We are highly indebted. It has been an absolute honor to have you amongst us, sir. Thank you so much, sir. Thank you so much.
Thank you. I thank you, Dr. Shobhaji, and your the dean of the
Sir,
law
it was
school.
pleasure having you.
And I tried, the time was limited, but certain points that we have discussed will be useful to the students. I really enjoyed delivering this class. Thank you, one and all.
Sir, we also enjoyed, and you are our family member, sir. Yes.
Okay.
Thank you, sir. Thank you.
For your affection. Thank you.
Thank you.